Judgment in the matter of R on the application of HC versus Secretary of State for Work and Pensions and others.
Lord Carnworth will hand down the judgment to the court.
In 2011, in a case known as Zambrano against the Belgian Office of Employment, the European Court of Justice decided that a member state could not take measures in respect of a non-EU citizen who was the primary carer of an EU citizen, where those measures would effectively deprive that dependent EU citizen of the genuine enjoyment of his or her rights under EU law. Following that ruling, the UK government introduced regulations, the intended effect of which was to limit the potential of that decision by precluding Zambrano carers, as they became known, from claiming various mainstream welfare and housing benefits under national law. The legality of those regulations is the subject of these proceedings. They are brought by Mrs. H.C., an Algerian national. She no longer has a personal right to remain in this country, but she has two children who are British nationals, following her marriage in 2010 to a British national from whom she has since separated. She and the children are currently receiving financial support from the Oldham City Council, in whose area they are living, under Section 17 of the Children Act 1989. She contends that the denial of such benefits to a Zambrano carer and her children is unlawful because it amounts to unlawful discrimination under Article 21 of the EU Charter of Fundamental Rights and Article 14 of the European Convention on Human Rights. Her claim failed in the Court of Appeal, and the Supreme Court unanimously dismisses the appeal. The majority judgment is given by myself. Lady Hale gives a concurring judgment. The Court finds that the reasoning of the European Court in Zambrano turned solely on the risks that dependents might be forced to leave the EU, thereby being deprived of the enjoyment of their rights as EU citizens. The right so given is not a right to any particular quality of life or standard of living. EU law requires no more for the children of a Zambrano carer than the practical support necessary for them to remain in the EU. That is being provided by the Council. Article 21 of the Charter of Fundamental Rights does not assist her. By Article 51, the Charter applies to EU member states only when they are implementing EU law. It cannot be relied on to impose a higher standard than implementation of EU law requires. Nor do the regulations amount to unlawful discrimination under Article 14 of the European Convention on Human Rights. The allocation of public funds in the social security context is primarily a matter for national authorities, provided that allocations are not, quotes, manifestly without reasonable foundation, which these are not. Although Section 17 of the Children Act is not an issue, the Court notes that it has formed an important aspect of the government's response to the Zambrano principle. The allocation of that responsibility as between central and local government is a matter of domestic law on which further guidance may be appropriate. In her concurring judgment, Lady Hale adds further comments on the application of Section 17 with which the other members of the Court agree. She also makes comments on the potential operation of Article 21 of the Charter.